today, we're going to talk about what marginal employment really means under 38 CFR 4.16. We'll talk about some cases like Faust, haven't said that one in a while, Ray, and more. This is one of the most confusing topics in TDIU, the TDIU space and TDIU claims. And online forums are often filled with contradictory advice and information. So we want to give some clarity as much as possible to marginal employment for TDIU purposes.
There are really two categories that we're talking about when we're talking about marginal employment. There's income-based and there's protected employment.
Right.
So for income-based, this is when someone is earning income, but it falls below the federal poverty threshold. The federal poverty threshold for one person is automatically considered marginal. What is the federal poverty threshold? VA uses the Census Bureau poverty threshold, not the HHS poverty guidelines. So if you just search for the federal poverty threshold, you could end up anywhere.
Yes.
On the Census Bureau website, though, thresholds vary based on age and household composition. But for TDIU, VA always uses the weighted average for one person, regardless of how many dependents the veteran has. So a tip is that the Census Bureau actually provides 3 different numbers for one person. There's an overall, there's an under 65 category, and an over 65. CCK Law typically uses the overall number, which is the first number in that Census Bureau table. This threshold is 15,940 for 2024, which is the latest number available. One really important thing, underreporting income is highly discouraged.
Right.
And note that VA often does verify earnings through SSA, IRS income reports. So, if people are underreporting or they've got the wrong numbers in there, VA will typically find out. This can create some problems.
Right. There's a lot of misinformation on the internet about income. And so just know that 1, VA is using this number. We talked about the Census Bureau number. And 2, they're looking at what you made at the end of the year. And that's really it. It's just simple math. All right. So the second avenue here is sheltered or protected employment. So this is for even if your earnings exceed the poverty threshold, the veteran can still be considered unable to secure and follow substantially gainful employment if that job they're working is sheltered. And so there is no formal definition for that in statute or regulation. The regulation mentions examples such as a family business or sheltered workshop. And it suggests a workplace where a veteran receives special accommodations, maybe held to a less rigorous schedule or productivity standard, or they're shielded from the competitive demands of the open labor market. We talked about this a little bit earlier, but a CCK case, Cantrell versus Shulkin, talks about how VA has to evaluate a protected environment on a case-by-case basis just because we don't have a uniform standard. And so what does that look like? Well, we pulled some past examples just to give. And again, this is just, case by case. So you may fit these and it still might not work out. But some past successes we've seen are working for a family member who excuses excessive absences or reduced productivity. Basically, the takeaway is if it wasn't for the fact that, Uncle Joe employed you, you would have been fired a long time ago. Jobs where you're not held to the same expectations as peers in the same role. Maybe your employer is a fellow veteran, understands your limitations, wants to help you out. But for these accommodations, you likely would not have the job because you're not living up to what your peers are expected to do. Or the employer even creates an entire role just for you and modifies duties and schedules solely to accommodate your disabilities. So those can be some examples of protected work environments. It's easier, we think, unclear, but easier, we think, to argue for protected work environment if your income is below a certain point. So there's still an income component to protected work environments. We got some guidance here recently from the Court of Appeals for Veterans Claims in 2025, the case of LaBruza versus McDonald. The court there looked at a couple other statutes that establish different income thresholds from the poverty threshold that the Census Bureau talks about. So first, one tool is to look at the annual pension rate established by 38 U.S.C. 1521. And the second tool is to look at the income limits for VA healthcare purposes found in 38 U.S.C. 1722. So the maximum pension rate, that first tool, is pretty low, and it's pretty close to the poverty threshold. But it increases if you have a dependent spouse or dependent children. So unlike the Census Bureau number, where VA is only going to look at the threshold for a single individual, under this analysis, that number goes up if you have dependents. And so, for example, a veteran living here in Providence that has 4 dependents would be entitled to free VA healthcare if their household income was under $30,922 versus the 15 and change you mentioned under the poverty threshold. So in theory, you could be working in a job with all these accommodations and special limitations we mentioned, earning up to around that $30,000 mark, and might be still entitled to TDIU. It's complicated, though, and it's not a straight one-for-one analysis. So you really need to talk to someone who's knowledgeable in this area of the law before pursuing protected work environment, TDIU.
So having income below the poverty level is not itself proof of TDIU.
Right.
You need to demonstrate that functional inability to sustain gainful employment. Ray v. Wilkie provides a functional test for marginal employment questions. They'll consider attendance, reliability, ability to handle stress and supervision, productivity and pace, and communication limitations. A veteran who technically works but cannot sustain competitive demands may still qualify for TDIU.
That's right. So strong evidence would be employer statements describing special accommodations. The VA form I mentioned, we had an earlier discussion about TDIU in general. VA loves their forms. So VA form 214192 goes to your employer. If your employer happens to talk about reduced hours or repeated absences in that form, that can help out. Pay stubs showing part-time employment, sporadic employment, seasonal work. Your Social Security earnings statement can also help with that. Lay statements about failed work attempts, and even termination records or performance evaluations. So, like I said, TDIU is complex. It continues to be a developing area of veterans law, and experience really matters, particularly when so much is on the line. So this is a classic situation in which you really want to consider getting some seasoned help with your claim.